And now they've got the delight again. It's wonderful to welcome one of my honorary guests, founder and director of CEDAWinLAW, is Joanne Welch. Good afternoon, Jo. How are you?
I'm very well, thank you, Ian, and good evening to you. It's a pleasure to be here, as it always is. Thank you.
And we had Dr. Jocelyn Scott's interview before, which was outside the cabinet, wasn't it, from when you went to number 10?
Yeah. We went to number 10 and we recorded Jocelyn presenting Women's Parliament motion and reasons for mediation to the Prime Minister. And then we did an impromptu video outside the Cabinet War Rooms, which, you know, apologies for the background noises, but those things were needed to be said. So, yeah, I mean, it was a great afternoon. I think we've been there a dozen times now, which who would have thought that it would have extended to that long? You know, we have a winning hand legally, morally and ethically, and that's been enhanced by the UN, the Commission for Status of Women, Jocelyn's, Dr. Scott's Women's Parliament, and they were all fed into the a presentation she made to the APPG. You know, we have grounds for a judicial review, and the strategic architecture forcing mediation via a high court case management exists. But, you know, it's very important to impress upon others that, you know, to be reasonable, cooperative and pragmatic at this stage. You know, there's no need for a fourth judicial review in Wasby's case. And, you know, we have grounds for a judicial review, but we'd much prefer mediation and getting into the settlement arena. It just makes sense.
Yeah.
You know, it's very disappointing, as Dr. Scott said, that, you know, the government appears to be cocking a snook at 3.5 million 50s women when there's legal grounds to hold them to account. And as she said, failure to consult, they restricted the consultation to a private company that represents 7% of victims.
Yeah.
And she spoke about bias, and I mean, the list goes on. It's extraordinary that we have this winning hand, and some are looking a gift horse in the mouth. That's so. Yeah.
So we've got a few questions to go through, haven't we? Which is the first one. Yes. I think you might have answered some of this already, but Dr. Scott spoke.
Go ahead.
Dr. Scott spoke of bias and discrimination against all 1950s women as embedded in the Judge's Report 2022 out of the CEDAWinLAW's People's Tribunal. Also, that clear grounds exist for CEDAWinLAW to mount a judicial review post Secretary McFadden's statement made at the dispatch box in January 26. She stated that the 1995 State Pension Act passed in repudiation of the Convention on the Elimination of All Forms of Discrimination against Women. As she put it, the government is thus cocking a snook to all 3.59 1950s women.
She is. And you know, Ian, I won't go over what I've just said, which, as you say, kind of answered the question. What we think is there's a case now for the Attorney General to intervene. CEDAWinLAW respectfully submits that the Attorney General is uniquely positioned to bring about a just resolution and urges him to consider the following courses of action, which are to provide the Cabinet with a formal legal opinion on the government's exposure under CEDAW international treaty obligations and the strength of the fresh judicial review grounds, as Dr. Scott laid out on CEDAWinLAW's behalf. And also to advise the Prime Minister directly that the evidential record, including, for instance, an FOI disclosure of 9.8 million male auto credit recipients, significantly undermines the government's existing legal defence. There's 7 of these. I'll go through them quickly. To recommend to the DWP and the Magistrates' Treasury that resolution through mediation is demonstrably in the public interest, avoiding protracted, costly and reputational damaging litigation. To advise Cabinet that continued refusal to engage in mediation materially increases the government's judicial review vulnerability, particularly in the light of Churchill versus Merthyr Tydfil, which is case precedent, by the way. Number 5, to facilitate formal engagement between CEDAWinLAW's legal representatives and the government legal department as first constructive step toward mediation. 6, to formally acknowledge that the United Kingdom's CEDAW treaty obligations engage an affirmative duty to address discriminatory outcomes and not merely discriminatory intent. 7, to advise that continued inaction risk referral to the UN CEDAW Committee with consequent damage to the United Kingdom international human rights standing. And by the way, we say this with the greatest respect post Lord Herner, the Attorney General's statement. He said, if ministers defy your legal advice, you must report them to the Attorney General, which we've done, by the way. And as we say, he's uniquely positioned to bring about a just resolution. And I think it's time for that. We've asked the Prime Minister several times, and he's busy fighting a leadership challenge at the moment. It's time. We've fought for all the layers of government and the courts. It's time now for the man who says, if ministers defy your legal advice, you must report them to the Attorney General. And so we have. And it's time for that. This nonsense has to stop. It really must.
Yeah. Now, thanks, Jo. Under civil procedure rules, application to court, a judge is able to consider an order to bring disputing parties to joint mediation, which I think you've just mentioned. WASPI Limited board members and their solicitors have yet to provide formal written reasoning for declining CEDAWinLAW's invitation to join such inclusive mediation. Were CEDAWinLAW and WASPI Limited to jointly apply to a court for such an order, would the government be required to attend mediation?
Well, what would happen is that the court itself, they're not fond of claimants wasting their time. They look for reasonable, cooperative, pragmatic claimants. And I think, even though, I'm talking about CEDAWinLAW, I do really think that a judge would be sympathetic, because we want to stop wasting time. We want to get on with the job, get into the settlement arena. We've received refusals to attempt to settle, and this litigation, in my view, might be deemed disproportionate to the issue itself. And as there is a solution that's presenting itself, it's bewildering why anyone would not want to embrace that opportunity. CPR rules, they can order mediation or a stay of proceedings to allow mediation to go on. I mean, silence from some parties, that won't be looked upon favourably by a court. They think that by being silent, that excuses them and in some way produces our evidence trail. There is persistent bad faith engagement, and this sets up a court application, actually. So we're very confident about our position, and we're trying to be, as I say, reasonable, cooperative and pragmatic. And, the judge looks for proportionality and protection of resources. And that's what we're trying to do here. It's so sad that some don't share that view.
Thank you, Jo. But on to the next one. We've got, in fact, no litigation need be placed to make such an order. Waspy Limited need not make an attempt to mount a fourth judicial review. Is that what you are suggesting?
Yeah, I mean, but we can go to court, say, even as a litigant in person, be no litigation in place, explain the situation, and make an application for either a stay of proceedings or an order for mediation. And we feel we've got a very strong case in that regard. So, yeah, there's no litigation need be in train. So no crowdfunders need be in train. I think women are looking for a return on their investment over the years, and we have estimated the grand total of what women may have donated to see justice, and I think it's time now to get the job done, and the easiest, swiftest way to do that, to avoid delays, to avoid extraordinary costs, is to do it now. And by the way, we had a JR on mediation last year, and this is widely known. We ran out of funds to complete it, but we're suggesting that had that proceeded, that it would have been successful. And by the way, Waspy Limited expressed an interest in becoming an interested party to that judicial review. So what puzzles us is, which they then retracted, but what puzzles us is why they don't, they're interested in our judicial review regarding mediation, but they don't want to join forces with us to bring about mediation by bringing the government to court. I mean, it's just so bewildering. We've asked them for explanations, but as I say, they prefer to be silent.
Right, Jo, thank you. Why would such an opportunity be seemingly overlooked when you have, as you have stated, a top 500 ranked team of mediators on standby to be considered for the neutral role?
Well, you know, this team that's on standby to be considered for the neutral role is a gift to 50s women, a gift, because what that's saying is that we have standing in our position. And when I say we, I mean 50s women, all 50s women have standing in their position to call for mediation. And, you know, some who may be seen as procedurally unreasonable and even irrational may face cost sanctions and exposure. Yeah, I mean, the list is so long. Yeah, they could even face reputational damage. It's that bad. That, obviously, that would be for the court to decide once they've heard the evidence. But, it just is bewildering. Totally bewildering. That the law is on side, international law is on side, and the Attorney General's position could easily end the reputational damage to successive governments by, doing as I suggested. It just bewildering doesn't cover it. It's a huge concern for all the victims who are, to say that the victims of being cruelly treated doesn't cover it. In my book, it's barbaric what's happened to 50s women. It really is. I don't know how they're coping. That's the short version.
Thank you, Jo. Ratified CEDAW International Law Treaty, General Recommendation 40, facilitates women leading at such decision tables. CEDAWinLaw's winning hand called for government to come to the table without further ado. Why would anyone seek to look such a gift horse in the mouth, is I think what you've said.
Well, why would they? The State Party must adhere to articles and general recommendations of the CEDAW Treaty. They've already been found wanting in Dr. Scott's President's report out of CEDAW's People's Tribunal 2021, where we had a team out of Garden Court Chambers, pro bono, by the way.
Yeah.
We live streamed out of London from Conway Hall. I think I'm right in recalling that there were about 40 witnesses. And, it was a magnificent event. We were really delighted with it. It was all done, with pro bono lawyers and silks. I mean, a team, I think, there were 8 of them, I think. I mean, there were international experts giving their advice. It was just fantastic. And all that anybody ever did was try to deduce our work. But I'd like to see them do what we achieved then. I'd like to see them do that in the middle of the pandemic as well. There are obligations, and the GR40, women leading at decision tables, is another reason why that all women are entitled to be consulted in this regard, not just one private company that represents 7% of women victims. It's everybody has a say here, and LJR grounds point that out. And we could easily mount another judicial review, but I think victims have had a bellyful of judicial reviews, and now's the time for the truth to have an outing, and for the Attorney General to look at his position and what he can do to not least, restrict the reputational damage to successive parliaments, governments in this matter, and make sure that laws are adhered to. He said in a statement as well, about the importance of international law. It's in the national interest, he said. We've got that video. And so you can't say one thing and then do another.
Yeah. Thank you, Jo. Yes, very important that. Now we're bringing in a mention of David Hankey here, veteran lobby correspondent David Hankey, who has written extensively about this injustice, stated CEDAWinLaw's censored winning hand remains in play. No funds nor any legal challenge is required to do so, whilst the One Bright Light prepares to tell the story, and has censorship blighted CEDAWinLaw's light to tell the story?
Absolutely not. In actual fact, it gives us energy to do so, and the story will be told. And what story it is, by the way. We're working behind the scenes to move that along. And younger generations, particularly of women, will look back on this epic injustice and come to their senses, frankly, and wonder about our elected representatives when they have elections, say one thing and then do another once they're in power. No, it's not acceptable. And by the way, Labour put on the table £58 billion in 2019 as a debt of honour. Now they dare not speak of any debt of honour. And, you know, we don't think for 1 minute that they'll put £58 billion back on the table. But there is a lot of wriggle room to improve on the £1,000 to £3,000 compensation for those who wish to queue at the DWP and prove their eligibility. No, that's not an acceptable package to us. And we uniquely represent all 1950s women.
Yeah, now, Jo, I think you want to sort of raise people to take action, don't you?
Yes.
The 50s women to support the inclusive mediation.
Yeah, I just want to thank everybody for their support in the face of unbridled censorship across the board, you know, to, yeah, well, let's not say why they're doing it, but, we want to thank everybody for their support. And what I'd like to say to them is keep going and keep calling for mediation. Call it from your local councillors, from your MPs, from the press, anyone you're speaking to, just tell them the story of how you've been treated, because this story will echo in eternity on the right side of history, and so will 50s women, despite everything.
Thank you, Jo. Thank you very much. Now, you've picked the last record. This is the one you especially wanted us to play, wasn't it? Do you want to say a little bit about it?
Well, we are unstoppable. 50s women are unstoppable. CEDAWinLAW is unstoppable. The One Bright Light is unstoppable. And we thought that it would be appropriate to have this number played.
Right, Jo, thank you very much, and thank you for your time today, and much love to all the 1950s women.
Thank you.